Good evening, everyone. Welcome to this year's seminar, Guildford Chambers. I'm delighted to see you all. I'm George Coates. It's my lot to start off with an update on financial remedies. And so what I'm going to do is just whiz through a few areas rather than trying to tackle everything that's happened in the last 12 months, just to identify important things. So the first thing I'd like to point out is about the importance of non-court dispute resolution now has found its way more so into the family procedure rules. And we have here FPR 3.3, the court must consider every stage in proceedings whether non-court dispute resolution is appropriate. And when the court requires, a party must file and serve on all other parties in the time period specified by the court a form setting out their views on using NCDR. So it goes on. Where there is sufficient time to do so, the court should encourage the parties to enter into NCDR. And importantly here, the rules have been changed. This is with effect from the 29th of April of this year. The important thing is the court does not need the parties' agreement to adjourn for NCDR anymore. It can mandate it, whether you like it or not. It goes on. The FPR doesn't give the court the power to require the parties to attend, but the court must have a duty to consider it. And when you get into the rules here, that there are certain situations when you are required to file a form 7 days before the first on-notice hearing in the proceedings. So these apply to financial remedy proceedings where the MIAM requirement is applicable and private children law proceedings, again with the MIAM requirement applying. It does not apply to proceedings where the domestic abuse exemption to MIAM is applying, or children cases where a Form C1A has been filed. The pre-action protocol for financial remedies. This is worth reading. It's tacked on to the end of Practice Direction 9. And it's worthwhile just looking carefully at the wording here. To comply with the protocol, the court will expect the parties to have done the following. First of all, attended a MIAM. Secondly, considered, proposed, and engaged in appropriate non-court dispute resolution. C, provided full disclosure. D, set out their position. And E, attempted negotiation. Now, if you go on through the rules, you will see under paragraph 12 that non-court dispute resolution, correspondence is not enough. It doesn't count. Furthermore, a roundtable meeting, however, might be considered sufficient. Furthermore, paragraph 14 says it expects attendance at non-court dispute resolution. And one must assume that means physical attendance, albeit in some cases remotely. And a failure to attend, and it uses that word attend, is an express reason for the court to depart from the usual rule of no order for costs. That's in the family procedure rules. So these are to watch out for. In the case of NA and LA, it was a return date of various applications, interim applications,
And in the meantime, the wife issued financial remedy proceedings and maintenance pending suits application and a legal services order application. So she had kind of piled in, and the judge said, I'm sorry, you've managed to sort out certain issues today. Basically, the urgent interim issues were resolved. And the judge ordered a stay of the proceedings, even though it was a domestic abuse case, even though the wife alleged non-disclosure, and even though it was a big money case. So there was a good example of judge taking the bull by the horns, I suppose. There is no need for financial disclosure to be given prior to engaging in NCDR. NCDR will provide for disclosure to be given, and many forms of NCDR have teeth. Well, the arbitration rules provide a mechanism for getting a court order for disclosure, even if you are in arbitration. The case of GH and GH, what had happened there was that at a hearing, a judge made various interim orders and dispensed with the requirement of an FDR. And the one party appealed, the husband appealed, and on appeal, the judge deprecated the concept of vacating an FDR, bypassing an FDR. Says that the wife argued there was a factual dispute about her earning capacity, and therefore it meant an FDR would be difficult, and that her position had not crystallized, as she said. So the judge, Mr. Justice Peel, head of a financial remedies unit, he said it is only in an exceptional case that you will be able to bypass an FDR. Moving on to this case of HO against TL, rather unsurprisingly about a hotel. Here, this was about costs, litigation, conduct, and so on. And the point here was that the wife had failed to negotiate properly and sensibly. And her first offer was 17 million. Her second offer was 12. Her third offer was 10. And she eventually got 7.5. And the judge felt, in light of the husband's offer of 6.5 at a fairly early stage, that she was clearly the unreasonable party and made a costs order. And at the same time, he noted that a number of factors in the case, the husband was to blame for being evasive and legalistic about his trust's interests. But another factor was that the wife included various personal criticisms of the husband in her documents. And even though it did not add significantly to costs, it wasn't appropriate to make unnecessary allegations, and ordinarily this too might justify a costs order. So, judge is saying there, do not engage in this conduct, even if it doesn't, you can't prove it's driven up the costs. There might still be a question of a costs order and a negotiation point. Moving on to DH and RH. Now, the wife spent recklessly on legal costs, such that by the trial, the husband had spent $1 million and the wife 1.9 million. This the combined total represented 23% of the assets. So it was a significant hit for these parties. And what the court did was it added back 800,000 that the wife had misspent on costs, and then on top made a costs order in favour of the husband. So it is an important factor, isn't it, that a costs order doesn't always of itself redress the balance, because if you're sharing the pot out of which the costs have already been deducted, there's less to go round. So that's a really useful case to point out, an add back of costs. Experts and financial remedy proceedings. Well, this case is a case of GA against EL, which spells the judgment and the interim hearing was by Mr. Justice Peel, and his judgment starts off with castigating both sides' advocates and both sides for an excessive length of bundle and submissions being more than the 10 or 15 pages or whatever it was, and so on. And therefore, the case being named Gavel may or may not be connected with that fact. It's nothing to do with the parties' names, that's for certain. I was instructed on behalf of the wife in this case by DMH Stallard, and I was led, and the other side had leading counsel as well. But the first reported decision here was about expert evidence, and significantly, this was about so the facts were the parties separated in November 19, and the business was sold in April 2022, realizing some 60 or 70 million, of which the parties were entitled to 50%. There was another couple who co-owned the business. The value had obviously gone up a lot, but the extent and the cause of this rise post-separation was very much in dispute. And an SJE was appointed, produced a report, and the wife's team, of which I was one, made a Daniels and Walker application for a second expert to be engaged. And I won't go into all the nuances, but this was very much to do with the methodology of producing backdated historic valuations and what factors you should take into account, whether you should take account of subsequent events or not, and so on. But it provided a judgment in which Mr. Justice Peel summarised the principles in these circumstances. And he really pointed out that, first of all, the reasons for the additional evidence must not be fanciful. Not terribly high bar, that test. Secondly, it's for the court to decide whether or not it's a discretionary matter. And thirdly, that the principles from the civil case of Cosgrave and Pattinson may fall for consideration. So you look at the nature of the issues, the number of issues, the reason for the expert, the amount at stake, the effect on the conduct of the trial if you admit the evidence, delay in making the application, delay in instructing and calling the expert, and so on. And finally, the final point is the overall justice to the parties. In this situation, he felt that the application was brought too late, that it might jeopardize justice to the husband, primarily because the wife's team would therefore have their own expert, but the husband would not have any chance to get his own expert if that's what he wanted to do. Any injustice to the wife could be ameliorated by using her shadow expert to raise questions of the single joint expert. And the next point, that the historic business value was only one part of the court's exercise. That there are many other factors in the case, he felt, that establishing a pinpoint value of that business in November 2019 is not the only issue in the case. And finally, he felt that the difference in the figures was not so great as to make a huge impact on the proceedings. That was his view, and it remains a very useful authority on single joint experts in these circumstances, BR and BR is a subsequent decision, also looking at question of experts. And here, at the very start of the case, a substantial case, the parties agreed that they would each have their own expert. They wouldn't have a single joint expert. And they got to the first appointment, and the judge said, well, you can think again then, can't you? And again, Mr. Justice Peel said, wherever possible, an SJE should be directed. And to depart from that default position is a high hurdle to cross. He pointed out the benefits of an SJE. First of all, cost. Secondly, independence. Thirdly, only one set of instructions. Where you have two experts who've been instructed separately, each one has their own set of instructions, not necessarily being asked to consider exactly the same thing. He highlighted the parties can still have their own shadow experts to help them. And finally, there's the right to put questions. He also said that an SJE has an advantage on the disclosure point, because it'll be for when you're looking at what material is needed, what disclosure is required from the company and in relation to the company, you can just leave the SJE to say what they need, rather than the parties engaging in lengthy questionnaires. Now we come back to GA and EL number 2, because the trial came up a while later before Stephen Trowell KC, sitting as a Deputy High Court Judge. He's now been appointed as a High Court Judge full-time. So here the question was, what is the relevance of any increase in value of the business post-separation, November 19 to the date of sale, April 2022? And it was the case of E and L, was a Nicholas Mostyn case, which said, in my view, and this was an important previous decision which had to be dealt with, in my view, there are already in this field too many uncertainties and subjective variables. The law needs to be transparent, accessible, readily comprehensible, and should propound simple and straightforward principles. In my experience, convention and tradition dictate that saving cases where there's been undue delay between separation and the placing of the matter for trial, the end date, for the purposes of calculation of the acquest, should be the date of trial. This rule of thumb should apply forcefully to assets in place at the point of separation which have shifted in value between then and trial. So in other words, what he's saying is, if there's a matrimonial asset, i.e. an asset that's been generated during the marriage, post-separation, if there hasn't been a delay in getting to trial, then you do not take account of any post-separation work contributions and so on. It remains 50-50, what he was saying. And this was followed, so Mr. Justice Peel, at the interim hearing about expert evidence, made a comment about this area of law, and he said, I doubt whether in most cases a historic accountancy report will add much. The most can be said is the value of a business at the date of separation may be relevant to the sharing principle, but multiple other factors may reduce or eliminate the relevance. Well, when we went to trial, the arguments, very briefly, were as follows. On behalf of the wife, we argued the case of Cowan and Cowan, which was a Court of Appeal decision back in 2001. We argued JL and SL, which was another Mostyn decision, which effectively says that it says that where there has been no new venture, where the business is still the same business and no delay, that again, we should remain on something like 50-50. We then argued another case, excuse me one second, which so that we argued E&L, and then finally we referred to a case called DR against UG. Unsurprisingly, that was about a drug company, and that case said that really the cases where post-separation endeavour should make a difference should be confined to certain circumstances, including perhaps where there is still more to do after separation to harvest the asset. In other words, a lot more effort is required to actually bring that value to bear, or where there's been a long delay, or where there have been earnouts or lock-ins in the business deal, so the husband has to remain employed in the business, let's say for 10 years, to actually fulfill the earnings, or where there's a new venture, or where the other party has already been bought out, has already received their entitlement. Maybe not an exhaustive list, but very much approved of the arguments in G, A, and EL. On behalf of the husband, it was argued that the value will be part of the husband's endeavours, not joint endeavours, because those endeavours have come post-separation. They pointed out cases, other cases, where work done before the marriage has been found to be important. So why should work done after the marriage has ended not count in the same way? Also, they pointed out that in this case, there'd been a big rise in value because of the markets. They said, well, yes, there may have been a following wind, but the husband still had to run. He had the wind behind him, but he still had to run. And they pointed out that in Heart and Heart, the Court of Appeal decision, the importance of non-matrimonial property. So they felt that the E&L approach was inconsistent with Heart. And Stephen Trowell KC, in giving his judgment at trial, really summed it up. An overnight calculation of post-separation of a case is likely to cost more than it's worth. But there may be cases where fairness does require a consideration of assets accrued by post-separation labour. A rule of thumb, like that propounded by Mr. Justice Mostyn, cannot act as a bar to fair assessment. So he looked at various factors and he gave a judgment which awarded 42.5% to the wife. So a 7.5% departure from equality. And he did it not in an arithmetical way. He noted that the value of the company and found that the value of the company had actually doubled between separation and sale. But a lot of that was to do with market conditions, the efforts and contributions of others, and so on and so forth. He couldn't come up with a formulaic approach. He came up with a by and large approach. In other words, he plucked a figure from the air. Why did he say 42.5% rather than 40% or 45%? We have no indication. So fairness at the expense of predictability. Standish is the final case I'd like to look at. This was a big money case involving cross appeals from a judgment by Mr. Justice Moore. The pot was 132 million. Initially, the wife got 66%. I'm so sorry. The husband got 66%. The wife got 33%. And the central point here was about £80 million of shares, which had been transferred by the husband to the wife late on in the marriage as part of a tax scheme. And these shares were shares which he had acquired prior to the marriage. They were largely pre-marital assets. And that's why there was a departure from equality. The judge said that they had largely been matrimonialized, but that there was for other reasons was the departure from equality, in fact. So just to recap, the trial judge said these have been matrimonialized because they were transferred to the wife. The wife appealed, saying, no, these shares transferred to me, they're now mine. The husband should have no interest in them at all because he gave them to me. In other words, the title of the asset is important, not the origin. The husband cross appealed. Apparently, he was not necessarily going to appeal at all. He said, no, you need to consider the source of these assets. And in the Court of Appeal, Lord Justice Moylan said the issue at the heart of this appeal is the classification of property for the purpose of the sharing principle, in particular, how and when property can change or move from being non-matrimonial and become matrimonial. And they sided with the husband's argument and, in fact, said that the source is important. In fact, they said there was nothing here which justified the conclusion that the importance and relevance of the source was in any way affected by the transfer to the wife. In other words, the transfer to the wife didn't make any difference to the categorization of these assets as matrimonial or non-matrimonial. For other reasons, they felt that 75% of the shares were still non-matrimonial. Only 25% should be considered matrimonial, and they gave the wife half of that. So the wife walked away with 25 million rather than 45 million, which she'd been awarded at trial. So that was an unfortunate decision to bring that appeal, one feels. But it's really useful guidance in how and when an asset becomes a matrimonial asset. Thank you very much. I'll pass on to Dominique.